So what is assignment of a contract? Generally, there are rights and obligations or duties between the parties to a contract, to the parties to the agreement. So if either party wishes to assign their rights or their obligations under the contract, then that's a transfer of the contract. So it can go either way, rights or duties. So if you transfer to me the duty to perform, then I now carry your duty to perform. If you transfer me your rights, and I have the right to receive the benefits that you would have received under this agreement. Okay, the assignor is the person assigning the contract, and the assignee is the person receiving the rights or obligations under the contract. Okay, now here's the important thing. An individual who receives an assignment under the contract of benefits, of rights, they have a duty to notify the obligor, the person in the contract who has the obligation to perform those duties, so that they will be the individual that actually receives those duties. So I'm a part of the contract and I transfer you my benefits or my rights. Now, I may later attempt to transfer those rights to someone else. It is incumbent upon you in most states to notify the obligor, the person who owes initially me, then you, the duties under the contract, that you have been assigned those rights and that they should perform those obligations for you and you should benefit from those rights. Now, there are certain types of contracts where you cannot assign the rights or the duties under the agreement. Examples would be, say, a supply contract. Another type of a non-assignable contract would be a contract that depends heavily on the specific skills of an individual performing that contract. Okay, now, say I do transfer an obligation. My transfer of that obligation does not relieve me from liability for failure to perform. Okay, so say the person I transfer it to does not perform the contract as they're supposed to. I'm not relieved of liability. You can still sue me under that contract. The only way I am relieved of potential liability is to do what's called a novation, an agreement between the three parties, the person to whom the obligation was transferred and the original parties to the contract, that says, okay, I, who have transferred this agreement, am no longer liable under the contract. We have a novation or a new contract between the transferee and other party to the contract. So those are the basic elements of transfer and assignment of rights and obligations under a contract.